Probation, a term coined by John Augustus from the Latin verb probare, which means to prove, to test, and probatio, which means testing period. As defined, probation is a disposition under which a defendant, after conviction and a sentence, is released subject to conditions imposed by the court and to the supervision of a probation officer. The Parole and Probation Administration has defined probation as a privilege granted by the court to a person convicted of a criminal offense to remain in the community instead of actually going to prison or jail. Therefore, a probation is just a privilege and not as a matter of right. It shall only be granted after conviction and sentence. There is no probation when the accused or defendant has not been convicted yet. Probation in the Philippines. Probation was first introduced in the Philippines during the American colonial period, during 1898 to 1945, with the enactment of the Act No. 4221 of the Philippine Legislature on August 7, 1935. In 1972, the House Bill No. 393 was filed in the Congress, which would establish a probation system in the Philippines. This bill avoided the objectionable features of Act 4221 that struck down the 1935 law as unconstitutional. Congressman Teodoro C. Natividad and Ramon Bagatsing introduced an act establishing probation in the Philippines, providing probation offices, therefore, and other purposes. On July 24, 1976, PD 968, also known as the Adult Probation Law of 1976, signed into the law by the President of the Philippines.
So what are the advantages of probation? The Parole and Probation Administration enumerates the following advantages. First, the government spends much less when an offender is released on probation than the offender being placed behind the bars or jails and prisons. Second advantage, the offender and the offender's family are spared from the embarrassment and dishonor of imprisonment. Third, the offender is able to continue working and can, therefore, earn income, pay taxes, and pay the damages to the victim of the crime. Probation laws. Mainly, it is the Presidential Decree No. 968, otherwise known as the Probation Law of the 1976, which provides everything about probation. However, some of its provisions were amended by the Republic Act No. 10707.
Who can apply for probation? Any sentenced offender not disqualified can apply for probation before serving their prison or jail sentence. Procedures in applying for probation. First, the offender or his counsel files a petition with the convicting court. Second, the court determines convict qualification and notifies the prosecutor of the filing of the petition. Third, the prosecutor submits his comments on such application within 10 days from receipt of the notification. Fourth, if petitioner is qualified, his application is referred to the probation officer for post-sentence investigation. Fifth, the post-sentence investigation report or PSIR is submitted by the probation officer to the court within 60 days. Last is the court grant or denies the petition for probation within 15 days upon receipt of the PSIR.
How a probation is granted. The trial court may, after it shall have convicted and sentenced a defendant for a probationable penalty, and upon application by said defendant within the period for perfecting an appeal, suspend the execution of the sentence, and place the defendant on probation for such period and upon terms and conditions as it may deem best. Probationable penalty is an imprisonment of not more than 6 years. An appeal must be taken within 15 days from promulgation of the judgment or from notice of the final order appealed from. Section 6, Rule 122 of Revised Rules of Court of the Philippines. Within the period for perfecting an appeal, the accused or defendant shall file an application for probation. As a result of such filing, the trial court may suspend the execution of the sentence and place the accused or defendant on probation and upon terms and conditions as it may deem best. Thus, instead of sending the accused or defendant to jail, the trial court shall put on hold the execution and place the accused or defendant on probation.
When probation is granted, what conditions are imposed by the court? The probationer must A. Appear before the probation officer within 72 hours. B. Report to the probation officer at least once a month. C. Not commit another offense and comply with any other condition imposed by the court. How long is the period of probation? A. Not more than 2 years if the probationer was sentenced to imprisonment of 1 year or less. B. Not more than 6 years if the sentence is imprisonment for more than 1 year but not more than 6 years.
May the offender be released when the application for probation is pending. At the discretion of the court, the probationer may be released. A. On the same bond filed during the trial. B. On a new bond. Or C. To the custody of responsible member of the community if probationer is unable to file the bond.
What will happen if the accused or defendant has perfected an appeal? As a general rule, the accused or defendant can no longer apply for probation once he or she has perfected an appeal. The law says that no application for probation shall be entered or granted if the defendant has perfected the appeal from the judgment of conviction. However, when a judgment of conviction imposing a non-probationable penalty is appealed or reviewed, and such judgment is modified through the imposition of probationable penalty, the defendant shall be allowed to apply for probation based on the modified decision before such decision becomes final. Thus, when a judgment of imprisonment of more than 6 years was modified imprisonment of 6 years below in an appeal, the accused or defendant may apply for probation to a modified penalty of not more than 6 years imprisonment.
Who are disqualified from applying for probation? Those who are sentenced to serve a maximum term of imprisonment of more than 6 years. Next, those who are convicted of any crimes against the national security. National security such as piracy, misprision of treason, flight to enemy's country, espionage, etc. Those who have previously been convicted by final judgment of an offense punished by imprisonment of more than 6 months and 1 day, and or a fine of more than 1,000 pesos. Next, those who have been once on probation under the previous of this decree. Next, those who are already serving sentence at the time the substantive provisions of this decree became applicable pursuant to Section 33. Next, those legally disqualified under special penal laws. Number 1. Offenders found guilty of any election offense in accordance with Section 264 of BP 881 or Omnibus Election Code. Number 2. Any offenders found guilty of violating Republic Act Number 6727 or the Wage Rationalization Act as amended. Number 3. Offenders found guilty of violating Republic Act Number 9165 or also known as the Comprehensive Dangerous Drug Act of 2002 with the exception sections of Section 12, 14, 17, and 70.
What are the consequences when the probation is terminated? After the period of probation and upon consideration of the report and recommendation of the probation officer, the court may order the final discharge of the probationer upon finding that he has fulfilled the terms and conditions his criminal probation and thereupon the case is deemed terminated. The case is also deemed terminated upon the termination of the probation. The final discharge of the probationer shall operate to restore to him all civil rights lost or suspended as a result of his conviction and totally extinguish his criminal liability as to the offense for which probation was granted. It is not only the civil rights of the probationer that will be restored, but as well the extinguishment of his criminal liability as to the offense for which probation was granted. Thus, his criminal record would be erased, even his record in the National Bureau of Investigation or NBI.
So the basic legal of a concept of probations, there are two-fold concept. First is as a conditional suspension of the executions of a sentence and as a personal care of treatment and supervisions over the probationer. The former denotes that the court assume a primary roles because of a grant of the probations is judicial functions and prerogative. The latter indicates the administrative inspect of probations through the supervisions of probations officer and from the point of the view of social worker, a social casework treatment.